Hey, good morning. All right, so I'm going to record a couple classes today. This first one is going to be specifically on force majeure. This is something I have not been able to get to yet, but it may be appropriate because now we get to talk specifically because we are now, today is just happens to be September 14th, 2017, and we are on the backside of Hurricane Irma, having rolled through most of our areas and or threatened to. And there's a lot of closings that are up in the air and a lot of things happening, so it's a very appropriate time. In addition to this, by the way, we will have, I'm going to have one on specifically post-hurricane uh, issues that will be a separate class that I'll try and record. I'm going to keep these as brief as I can, but I need to be detailed to make sure we understand. So force majeure. This is part of the contract that most of us kind of glance over. It's mentioned one other time in the contract, and I'm going to mention that. I'll talk about that in the other class. But I want to talk about this paragraph G. This is under um, uh, 18, section 18, which is provisions and standards, and it starts to basically it's a laundry list of different items, and I'm going to record G now because of its necessary appropriateness right now. Force majeure. Okay, let's just read it, and then I want to highlight a couple things. There's a couple things not highlighted on this right here that I want to make sure I note as well. Buyer or seller shall not be required to perform any obligation under this contract or be liable to each other for damages so long as performance or non-performance of the obligation, which means all the things that they're obligated to in the contract, or, remember this word or, this or right here on line 426 is very critical, okay? Or the availability of services, insurance, or required approvals essential to closing is disrupted, delayed, caused, or prevented by force majeure. Then it labels force majeure means hurricanes, floods, extreme weather, earthquakes, fire, or other acts of God, unusual transportation delays, wars, insurrections, or acts of terrorism, which, by exercise of reasonable, diligent effort, the non-performing party is unable in whole or part to prevent or overcome. All time periods, including the closing date, will be extended a reasonable time up to 7 days after the force majeure no longer prevents performance under this contract. Provided, however, if such force majeure continues to prevent performance under this contract, let's say a war or act of terrorism or whatever, more than 30 days beyond the closing date, then either party may terminate this contract by delivering written notice to the other, and the deposit shall be refunded to the buyer, thereby releasing buyer and seller from all further obligations under this contract. Now, this is actually very loaded. We don't realize it. We glance over it, but it's actually very loaded. Let's start from the very beginning. Buyer or seller shall not be required to perform any obligation under this contract or be liable to each other for damages, so as long as performance or non-performance of the obligation. Okay, the reason I said this or, a lot of times, because earlier in the contract it makes reference of the availability of services. And a lot of times what's happened is people are assuming that if services were still available, let's say the Friday before this hurricane that rolled through, you had, excuse me, I'm fighting a little bit of a head cold. We had title companies and banks that were willing and able to close. However, the path of the storm was taken in such a way that a lot of buyers and sellers were evacuating. They were making sure their families were safe, that they were protecting their businesses or whatever the case may be, and quite frankly, did not feel like they had the ability to close even though the bank was ready. So this or says that the availability of services is one of the reasons that it can be disrupted. But that or is very important because it also says under this that is if they are unable to perform any obligation. So let's say I have an elderly mother in Palm Harbor, and I'm concerned about boarding up her home, getting her evacuated, or whatever the case may be, and the seller is sitting at the closing table saying, "Why aren't you here?" I, as a buyer, believe, now again, let me clarify this. None of us are attorneys, and this is going to be fought out. There are going to be people that see both sides of this situation. So with that in mind, we have to bear in mind that whatever we do, we don't ever imply that this is for sure you're safe or whatever to the client. But you can say, hey, this is our reading of the contract. You are free to check with your own attorney and legal counsel, and I encourage you to do so. But I think it would be very hard for a seller to argue in a court 6 months from now that, Your Honor, they didn't show up to closing and I'm going to sue them for specific performance because the title company and the mortgage company were ready. And the buyer is there showing a picture of his 87-year-old mother that he had to get out of an evacuation zone. And that was the reason why he didn't come to closing. So um, what I'm getting at is a lot of times we're saying, well, the services were available, so they should have closed. I beg to differ. Now, this is my own take on the contract. Again, attorneys will probably argue over this both sides, but that if I had to do things like make sure that my family was safe and other whatever was going on, my business, I had to protect my properties, that was a valid reason for me not to perform at that time. Now, it doesn't mean we're out of contract, okay? So I want to make sure they got that clear. The definition, we've got this. For us, it means hurricanes. If you're in California, it means earthquakes. Could be fire. All these other things that could occur, right? They're acts of God, if you will. All right. So here's the big debate right now. A lot of people are asking, okay, do I need to get an extension signed? My theory and my belief is that reading this part of the contract under Section G is no, that there is no required extension. And the reason being is the extension already automatically kicks in. All right. It says that it will be extended. All time periods, including the closing date, will be extended. All right, is what it says. Um, uh, Sorry, my phone rang. Let me shorten that up. Will be extended a reasonable time up to 7 days after the force majeure no longer prevents performance. Now, there's a case to be made. Hey, I evacuated my 86-year-old mother to North Carolina, and I'm up here getting her back now. So I have up to 7 days after I'm no longer prevented. Now, again, that would be stretching it in my opinion, but what needs to happen in again, this is me, is that everybody needs to step back, take a breath, and make sure that we all work together to get these closed. Buyer still wants to buy, seller still wants to sell. Now, are there reinspection issues? Yes, we're going to cover that in the post-hurricane class, but I'm just covering force majeure in particular here. But per the contract, it automatically extends. You don't have to get an extension signed. Now, could the lender, if there's financing involved, require that, hey, look, we need to see an extension? Yeah, they may. All right, you could point to this, and I would point to this, whether you're talking to a lender, whether you're talking to the other side, whether you're talking to your own client that you represent. Hey, look, we've already got an automatic extension. You can't just change your mind and not sell it because you think you can get more money for it now. You can't change your mind and not buy. And well, you can, but you better be prepared to deal with the fallout and the potential specific performance suit that could be brought on you. Okay. So up to 7 days. Now, let's say we have this thing gets extended and it gets to more than 30 days. Now, again, if the buyer's just dragging their feet because they have changed their mind and they're going to try and claim force majeure for 30 days, there's a case, I think, that could be made that, hey, look, you can prove that the buyer had the ability to close. Everything was back to order. Everything was fine, and they could have closed, and they're just dragging their feet trying to get out of the contract. That's going to happen. I guarantee it. Same thing on the seller side. They're going to drag their feet saying, oh, I can't get everything ready to go. Oh, it's 30 days, so I want to cancel because they've got somebody who wants to buy it for more. Are there going to be fights over this? Yes, but I want to let you know that I've got 80 phone calls since this hurricane has passed asking if I need to get an extension signed. Ideally, you have one, that's fine. But in my opinion, you don't need one because it automatically extends. All right. Now, at the end of the 30 days, if we can't get it closed and everybody has done their best, there is no dragging of feet, then it says either party may cancel, the money's returned, earnest money's returned to the buyer, and then the buyer and seller are released from the obligation. Okay. So that is force majeure in a nutshell. All right. Don't forget this or. A lot of times it's not just whether or not the title company, the mortgage company, and insurance was available. There's some leeway here, in my opinion, for non-performance other than, even if, I should say, those services were available. All right, so that's force majeure in a nutshell. I'm going to reference this in the other class that I'm going to have about dealing in a post-hurricane month. and what we're going to do to get these deals closed that are under contract. But I want to make sure you had this down. I'm going to reference this. So if I reference it, and if you haven't listened to the other class, listen to that. And when you get to that, I'm going to tell them to make sure they listen to this class as well. Thanks, guys. Have a great day.